Hi, welcome to iGlobal, the great big Indian money show. Today we're going to be talking about money after death. I am Rumit Shah. I would like to invite the speakers today. The speakers are Yogesh Nagpal, who is the Director and Protection Insurance Specialist at Aegis Life Financial Services Limited. Uh, Hari Mistry, who is a solicitor at Russell and Russell Solicitors. Ed Robinson, who is a director at Keystone Probate, and Pranav Barnot, who is a solicitor at Meeby and Co. Solicitors. Uh, okay, so guys, welcome all. Let's kick off the session. As you know, it's a very sensitive issue when somebody dies. And not only that, in the last year, we've noticed a lot of deaths coming out of the pandemic when it is unexpected deaths in the family or whatever. And it's been a hugely stressful time for a lot of people. And so today, what we wanted to do was to talk about what happens to money after death. Uh, some of the things that obviously immediately should happen after somebody's died is looking at wills, etc. And I would suggest, is it Hari? Hari, would you like to talk about just what the position is with respect to wills that people have?
Yeah, sure, not a problem. So after death, usually after the funeral, there's two sort of strands. If an individual's made a will, you need to locate the original will. It's usually the executor's responsibility. So if an individual has made a will, the executors will be named in that will. So they will then obtain the original will, look to administer the estate. Obviously, if an individual has not made a will, then the rules of intestacy would apply, and it would be the next of kin. So that could be a spouse, children, grandchildren, who would then be responsible in terms of administrating the estate. So, I mean, I think there's only about 56 people in the UK that do have a will. I think the pandemic has highlighted sort of concerns for a lot of individuals. So I'm now seeing a lot more in the last year, individuals making a lot more wills, even young individuals, because usually young individuals who may be sort of working professionals, young children, they're on the basis of that we've not got anything to sort of leave at this moment in time. But the pandemic has been a sort of game changer in regards to this. So that's the initial sort of starting point. Need to locate the will. Who are the executors? So the executors are the individuals that will administer the estate. And it's their responsibility to gather in the assets of the deceased. That could be bank accounts, find details about stock, shares, policies, as well as any debts the individual may have had, mortgages, credit cards, loans. And then there is, dependent on the value of the estate, so if there's going to be inheritance tax to pay, there's sort of two different areas which you can sort of go down on. If it's an accepted estate and it's straightforward, there's no tax to pay, you have in the region of 12 months to get all the paperwork which is necessary filed off to either HMRC and the probate registry. If there's going to be inheritance tax to pay, then the clock starts running in terms of 6 months from the date of death. So it's a process of collating all the assets, finding out how much inheritance tax needs to be paid, and then paying that to HMRC before you can then make the application for the grant of probate.
Okay, and that gives me a great segue into Ed. Ed, who is our probate specialist. Perhaps Ed, you can just highlight what you have to do to make sure that the probate is done in a very efficient and quick manner.
Well, certainly COVID has had a huge impact on the timescales to get the grants probate. So when somebody dies, normally all the assets in their sole name will be frozen until the grants probate is issued. There are a few exceptions to that, but one of the big problems with COVID is financial institutions aren't giving the information in a timely manner for you to complete the inheritance tax forms. And we've had, as well as that, huge problems with the probate registry. We've had delays. They used to have a service level of about 4 weeks to return the grant, or less of administration if it was an intestacy. So 4 weeks used to be the normal. That's increased to a minimum of 8 weeks. And we've encountered serious delays on quite a few cases where the applications were made probably from about August last year, where 4-5 months have basically materialized. Mm-hmm. So if you imagine, as we probably discussed earlier, a lot of the bank accounts and the assets were in the name of the husband. He passes away, and then suddenly you've got this huge delay of about potentially 5, 6, 7 months to get control of the money. You can see that it causes financial issues for the next of kin. But yeah, so it's been delayed to get the grant. But yeah, things seem to be improving at the moment.
And is there a size of estate that go through probate? Because obviously there are people who will have only a small amount of assets and other people will have larger estates. So is there a certain balance there that we need to know about so people know what to do?
It really depends about what the assets are in the estate and the value of those assets, and how they're held as well. So there's several different considerations. With regard to property, normally if there's a property held as tenants in common or in the sole name of the deceased, you're going to need the grant to deal with that property. If you've got cash at bank, really it's a sort of risk. The institutions draw their own conclusions from a risk basis. So if somebody turns up with a will showing them as the executor, it's up to the financial institutions whether to release the money or demand a grant. And obviously they're going to be responsible if they pay it away to the wrong people. Where their issue comes is that they don't know if that's the last will or they're paying away to the right people. So if in those circumstances, their risk assessment, for instance, Santander will pay away balances without a grant up to £50,000. If it's more than that, they'll demand a grant. Another one will be 10 grand. So it really depends on where the funds are held. So it's not so much about whether the estate's worth 200,000 or more. It's really about what's held where and the quantum of those assets. So it's very difficult to tell. But first calling points is speaking to the financial institutions, so identifying where the deceased had assets, and then speaking to them to find out what their thresholds are.
Sure, great. Pranav, if I may come back to you, what Hari said, that obviously a will is very important and what we need to find that immediately. Now, there are two types. Obviously, people may have done wills which are either DIY wills, or have them done properly at a lawyer's or anybody else who are will writers. Is there anything that we need to make sure that these are all legally and validly binding to look out for? What sort of things do we need to make sure of there?
That's a really good question. And firstly, can I just thank Ed and Harry for their insight. Perhaps where I come in with a slightly different perspective is that whilst I don't work with clients to write wills, I'm a litigator. So I come in where there is a dispute about a will, but your question is very well put. What is it that we can do now when drafting a will to be a bit more careful in the future to avoid a dispute between family members, beneficiaries under the will? And this is the great Indian money show, and it's no secret that people of the South Asian descent, they have a great ability to accumulate wealth, and there can always be some sort of often that I find not quite an equal kind of distribution, and I do find a lot of my clients who are contesting wills are from the Indian background, and certainly from the South Asian background. So if I may, if you could indulge me for maybe 30-40 seconds,
Sure.
I have tips that I would suggest anyone who's looking to make a will really does take into consideration. The first, and sorry if it sounds really obvious to members of the panel, but the first is making sure that you're not under any undue influence when writing a will. One thing that we did touch upon is, sometimes in an Indian household or a South Asian household, the male figure has a bit more of a say, has a bit more of control over the finances. And I think, if you are watching this and you are a female, it's very important to remember that you should be writing a will as you would like it to be done, fully and freely. And I think that's really the first point I really stress. Number two, one of the big disputes I deal with is there not being a reasonable financial provision for a family member. Quite often you'll have maybe, a few sons and a few daughters, and, some of them have got something and some of them have got nothing. And it's amazing, how that can lead into a dispute. So if you are going to write a will and you want to try and avoid a dispute, think very carefully about who you're giving to. And if you aren't giving to someone who is maybe expecting to receive something, it's important you have that full and frank discussion before drafting your will, and potentially putting together a letter of wishes to make it clear that what you put in the will is as you intended it to be. And I guess one final point is, particularly if you're of an older generation watching this, one thing I do advise my clients to do is, if you are going to write a will, to potentially get a doctor's letter soon after writing the will to confirm that you do have capacity in doing will at that time. Because one of the common disputes we have is, an aggrieved person saying, I was left nothing, my mum didn't have capacity, she didn't mean for, the intention to be set out as it is in the will. So if you can have a doctor's letter that supplements the will and you keep the two together, I find that that often does resolve many of the potential disputes. And I'm sure my legal colleagues on this chat may well have more to add in relation to that. But I hope that kind of gives an idea of how you can avoid disputes at the time of completing your will.
Yeah, that's very, very good advice, Pranav. If I turn to Yogesh, obviously a lot of people have life insurance policies, and in terms of what is the process that people should be following, because two things: one, before the life insurance policy is taken out, and obviously one after. What happens after that if there is a life policy, and what should be done to make sure that the proceeds of that policy are given out in a most efficient manner?
Oh, thank you. That's a very good question, and thank you to all the other contributors and the panelists for highlighting different areas of concern and obvious concerns in most cases. Let's go and talk about the setup first in terms of what happens in the event of making a claim. And first thing we need to highlight and realize that there's no rush, there's no time limit in order to make a claim. So people generally feel that, okay, if somebody passes away, is it a week? Is it a month? How soon can we make a claim? And if that time elapses, will the monies be paid? So one thing, just get absolutely clear, there's absolutely no time limit or rush to make a life policy claim. According to statistics, latest statistics, even with the COVID payouts, there's been a huge amount of payouts that have been made by insurance companies, and 99.6% of the proceeds have been paid out to people, whether it's COVID-related deaths or natural deaths. So UK as an industry, insurance industry, has got a very high record of paying claims. The only percentage of claims which haven't been paid out have been because of non-disclosure, Whereas, for example, somebody was a smoker, but let's say they do a DIY policy online and they say, okay, in order to get cheaper premiums, let me disclose that I wasn't smoking. Who's going to know? So one thing I would like to advise, I advise all my clients is please, please, please answer all the questions when you're setting up the policies to the best of your knowledge and belief, and be very truthful, because the underwriter and the insurance company has every right to cross-reference and check your records even after death, right? Just to make sure everything has been disclosed. In terms of the steps, we need to make sure that the death certificate is available. The insurance company, either you can contact your advisor or intermediary who can then help you in the claims process, or if you've done it directly, you can contact the insurance company as well. Request the claim form, you complete the claim form, and make sure that the policy document is in place. Now, as Pranav rightly highlighted, a lot of Southeast Asian families, and we've generally seen that the male of the house makes the decision. And in most cases, or a lot of cases I come across where the spouse or the wife doesn't even have any knowledge of whether there was a policy in place in the first place, where to find the document, what to do. So these are the things that as a family, I would advise that if you're doing something, that's fine. So why does anyone take life policy? It is mainly to safeguard and provide peace of mind to the family after you've passed away. In most cases, you are never going to see the money. It's the people after you that you're safeguarding, making sure that they have the financial comfort and security should anything happen to you. So if you're doing it for a family, make sure both parties are on the same page. Make sure that you are open and transparent, not just with your wife, in some cases with your family and children as well, if you're comfortable to do so. And make sure that they know where the policy documents are kept, whether it's in a digital form, whether it's in a file or folder. Make sure everything is organized and put in one place. So should somebody pass away, the information is there to hand. Now, coming to one step before how to set up the policy and what are the things that needs to be put into place. As we've kind of highlighted, and my esteemed colleagues have highlighted, that the issues that we are facing is the wealth, the estate, the value of the estate, the inheritance tax payable on the event of death before the grant of probate is applied. So one key thing, as I said, is just make sure that everything is disclosed. If you have any health conditions, make sure that's disclosed, because every insurance company has got its own underwriting process. There will be some insurance company who will accept certain clients of certain ages and health conditions. Their underwriting philosophy will be different to others. So cheapest is not always best. Make sure you take proper advice so the policy is suited to your needs. Point number two, and I highlight that, make sure you take advice from your tax advisor, or whether there is any inheritance tax on the estate. There are specific policies available. So if you're gifting any monies to your kids, there is a tax liability for 7 years, the inheritance tax liability for 7 years. There are specific policies available for that. Or if there is a residual estate as well, there's inheritance tax on which inheritance tax is payable. There are specific policies available to make provisions for that inheritance tax liability. So take advice, professional advice, and work as a team. All your professional advisors can help you to make provisions or mitigate the inheritance tax. Very, very important is putting the policies in trust. This is where, a lot of clients that I come across, they've taken policies many years ago and it's just there. It's not put into trust. So whether you can go back to the advisor or you can go back to the insurance company, or if you're taking a new policy, make sure that the policies are in trust. Make sure you speak to the trustees, whoever you appoint as trustees. Anybody over the age of 18, could be a friend, it could be a family member, anybody that you feel that will make the decision in the event of your death, speak to them. You might want to appoint them as trustees, but they might not be comfortable. It's a big responsibility. So have an open conversation. And since the last year, people have started having these conversations. So make sure you have trustees on the policy, make sure they know that if something happens to both the husband and wife, where do they start from? So all these things will help in making a claim. And I think that's pretty much from me. I think
that's a very, very good answer there. Very comprehensive. Thank you. Hari, can I come back to you? And I think Pranav helped by actually setting out what you should do beforehand in terms of wills, etc., in terms of making sure there are no disputes. But there is a thing called a deed of variation to the wills. People can actually vary the will as such after death. And what's the process and why would this be done? That would be helpful, I think, for people to just understand.
Okay, so a deed of variation allows the beneficiaries of a will, or if it's under the rules of intestacy, so the wife, the children, they could vary the will of the deceased. Now, the reasons for this could be numerous. One reason could be that a child or a stepchild has not been included, and the beneficiaries of the will now want to include that child. Another reason could be for tax purposes. If the will is varied and you're including exempt individuals such as the spouse, that's another reason why you would do a deed of variation. The third, inheritance tax currently is 40%. So anything above the exemptions and the allowances is at 40%. Now, you could also do a deed of variation to leave 10% of your net estate to charities. Now, if you did that, then the overall estate would then be taxed at 36%. So that is the purpose of a deed of variation as well. And it comes in very handy for individuals who may not be included in the deceased will. And it has to be done 2 years from the date of death. That is a requirement as well. So if a estate is going to be dragging on, that time factor needs to be taken into consideration and ideally diarised. It can be done before the grant of probate has been obtained as well. So that's you don't have to wait for the grant of probate before you do the deed of variation. But it's 2 years from the date of death with that you would do the deed of variation.
Mm-hmm. Okay.
And it can only be. Sorry.
Go on, you carry on.
Oh, that's fine.
Yeah, thanks. Pranav, just a very quick question. Obviously, you mentioned the disputes which can arise from, wills which are not necessarily either properly written or, just generally people think they haven't been left certain amounts when they should have been left, etc. And when people embark on these disputes, there's a cost involved. Obviously, the legal expenses can be fairly high. Can you allude to what sort of legal expenses that, can arise? Because obviously, certain times the assets might not be enough. And why are you fighting for something when the legal costs are going to take away everything?
That's such a great question. I think that's the $1 million question, isn't it?
Yes.
I'm sure the lawyers on this call will agree that the two biggest questions that litigators get asked, how much is it going to cost and am I going to win? Well, the short answer, Ramit, is that it really does depend on the nature of the dispute and to what extent your opposition is going to defend their position. And I know that sounds like a really legal answer. Lawyers have this habit of saying it depends, but it really does. Now, I think many lawyers charge on an hourly rate. Some lawyers may charge on a fixed rate for certain aspects of the litigation, but they can get very expensive. I mean, I can tell you one of the more recent disputes that I'm working on has clocked up around £10,000 worth of legal fees, and we've only really been doing about a month's worth of work up to now. Right. So there's an idea of actually how quickly costs can escalate. And actually, you've hit the nail on the head in the sense that many of these disputes settle, i.e. they don't go all the way to court. And the reason for that is because ultimately you may have family members having a fight over it, and it's actually their inheritance, it's their money that's being expended in order to fight each other. Because the assumption is the estate will be funding part or all of the litigation. So generally, you're 100% right. Parties should be looking to settle these matters rather than going all the way to court, because not only is it eye-wateringly expensive, time-consuming, but also, you could be kind of using the funds that you could otherwise be enjoying to line the pockets of lawyers and the courts. And that's me as a lawyer telling viewers this very point. So I think that's why it's probably important to bear in mind the advice given on this call. Be as diligent as you possibly can to avoid disputes. I think many people in the South Asian background can often be adverse. I think, well, there may be disputes, but it won't impact my family. But actually, disputes can come in all shapes and sizes, can impact anyone. So it's very important that you are as proactive as possible to avoid it, because ultimately the costs going forward will be a lot less by way of dispute litigation or anything like that.
And is there a body, like an arbitration body, which can help in disputes or settlements rather than just going to the lawyers?
Well, no, 100%. And in fact, there are numerous mediators out there that can be used to work and try to resolve these sorts of matters. And in fact, there is a duty on the parties to try and resolve disputes before going to court. In fact, court should really be the method of last resort. So, where you find yourself in a dispute, it would be most cost effective and time efficient to think very carefully about adopting the services of a mediator in the first instance.
Great, thank you. Ed, same sort of question to you in terms of probate and the fees that come along from not just the professional. Are there any other probate fees that need to be paid, etc., as well? Because obviously people would like to know what's going to go out from this.
Yeah, so for the administration of the estate, so dealing with the inheritance tax, filing the necessary filings, getting the grant, calling in the assets, transferring the assets if it's properties, all of that takes time. And just like any other sort of accountancy or financial advisor or legal profession, unfortunately, that does incur time costs. They vary greatly. Some of the banks charge a fixed fee for their probate services. It's not a fixed fee. It's on a percentage of the assets. So it's worth shopping around, getting quotes, seeing if people will do it fixed or their hourly rate, in order to obviously save money in dealing with it.
Great, thanks. I don't know if anybody has sort of any other sort of things that we should look out for. One of the things I was going to suggest was, I think Yogesh mentioned about making sure all your assets and things are somewhere either in a file or in a digital manner or whatever. One thing also to add to that, if I say this, is that a lot of people have different passwords these days because they have loads of different accounts, etc. And those passwords should also be kept somewhere, so that in the event something happens, at least you can go in and see what there is, because in many cases you might not even be able to work out what there is without that. So I think, Yogesh, does that make sense?
Absolutely. Having one thing I forgot to add in is the advantages of putting policies into trust is it avoids the need of going into probate. So when Ed, Harry, and Pranav said the delays that are happening because of that, people kind of say, okay, what are the advantages of putting policies into trust? So existing or new is the basic need of avoiding the need to go into probate. The money is paid much quicker, sometimes in weeks, rather than by the time the probate's granted, it could be almost a year. So that's very, very important in there. Like with wills, with insurance policies as well, you can also put an expression of wishes. So what do you want the monies to be used for, or how do you want the monies to be used for? Although it's not a legally binding document, it still gives the executors, the trustees, a bit of guidance to say, how you like the money to be distributed, and try and be as fair as possible to avoid litigations or disputes, as Pranav rightly pointed out. So yeah, these are the few things to bear in mind as well.
Great. Hari, just one point, and I know this doesn't impact money after death, but normally when you're writing a will, at the same time, you'll also do legal powers of attorney. Maybe you just want to quickly explain what LPAs are, because that may impact some of the things that happen generally, and it will help if there is anything that we need to know about that.
Yeah, sure. So it's a very good question, because I think the Indian community does know what wills are, but they're still very slow in the uptake in getting power of attorneys. So a power of attorney, what is that? So there are two types of power of attorneys. One is for property and financial affairs, and the other one is for health and welfare. Now, these documents, you can create them during your lifetime. You can appoint attorneys, as they're called. That can be your family members or people that you trust. Now, you get these documents done and registered, and even though you may not need to use them, they just gather dust in your cupboard at this moment in time. Thereafter, in the event that something happened to you in the future, you've got dementia, Alzheimer's, heart attack, stroke, or just old age, and you were no longer in a position to manage your finances or your health and welfare, then because you got these power of attorneys done when you were of sound mind, your attorneys, be that be your wife, children, or friends, they could then use this document to liaise with the financial institutions, banks, utilities, pension providers, in respect of health, it'd be your doctors and GP consultants, and they could then make decisions on your behalf. So I'm seeing a slow uptake in power of attorneys in the Indian community, especially in the Northwest. And I have been trying to sort of get the message out in terms of, yes, the wills come into effect once you've passed away, but you need to make the necessary sort of steps that are required in the event that something sort of happens. And the things I've come across, especially in the Indian community, is like, no, it won't happen to us, we won't get dementia, or it'll be fine, or I've got my kids and things like that. Those are the usual things I've come across. But I don't think they understand that if you've got a bank account which is in your sole name, say, for example, it's an ISA, so maybe your wife or your children, they still won't be able to access any of that money if it's in your sole name. I mean, there are other things which you can sort of do, such as third party, but to have full control would be a power of attorney, which would enable them to make it a lot easier for themselves as well. Now, you can only do a power of attorney like a will when you've got the mental capacity. Now, if you've not got the mental capacity and you leave it too late, then the door to making a power of attorney is closed for you. And then your family members will be left with no other alternative but to go down the court of protection route. So a court of protection route is where an individual's not got the mental capacity. There's only one court in the country that deals with that, that's in London. The application takes a significant length of time. We've talked about the length of time it's taking for probate applications, but I'm seeing now in my court of protection applications that it's taking in the region of 7 to 8 months. And not only that, the cost application for a court of protection application can set you back nearly £2,000 as well. Whereas power of attorneys are a lot more sort of cheaper. I mean, the only issues that I've come across in regards to power of attorneys, they're not sort of legal issues. It's mainly to do with the family members. Can you trust these individuals? I've come across cases where individuals have been financially abused in terms of children have dipped into mum and dad's bank account. And it should be noted that even though you're getting these power of attorneys done, you're there to act in the best interests of the individual. Irrespective of what's in the will come later, but the power of attorney is to support and help the individual if anything did happen to him health-wise. And
That's helpful. Yogesh, one thing I wanted to ask you, in terms of where you've got policies in an estate, and they are joint policies. So, money will automatically go to the spouse or the surviving spouse. Obviously, from an inheritance tax perspective, this may not necessarily be the most efficient way of doing things. And, that money just moves across. And if you've got children or whatever, should anybody be looking after that? Obviously, what steps can be taken to make sure things are actually could be put into place to avoid major issues on that?
So the answer to that is it depends on the structure of the policy and the reason why it was taken out. So for example, most of the joint policies that we see are generally taken out to cover an outstanding debt like a mortgage.
Mm-hmm.
So the idea behind taking a policy is that if one of the spouses were to pass away, the other spouse will get the money, which will then be used to pay off the outstanding debt. So from an inheritance tax point of view, it may or may not add to the overall estate, because inheritance tax is only payable on second death. Now, again, this is a question that I've been asked that by a lot of clients, that do I have to pay the mortgage out with the monies that have been received? The answer to that is no, because it depends on the individual spouse's discretion how the monies are to be used. There used to be a time, probably 15, 20 years ago, where banks and building societies used to issue policies, and that used to be assigned to them. So in the event of one of the spouses passing away, the monies used to be paid to clear off the debt, and any residual or surplus used to be paid to the surviving spouse. So it didn't really add to the inheritance tax as such. Whereas now the monies are paid to the surviving spouse, and it's their discretion. As long as the mortgage is paid, the banks or building societies don't insist. Where it comes to individual policies, it depends on, again, as I said, what's the purpose of the policies. If it is to make provision for inheritance tax liability or to pass down the estate, then potentially considering discretionary trusts could be one of things. So the spouse doesn't use it for day-to-day purposes, but it's earmarked for a particular purpose. So that's where usage of discretionary trust or other forms of trust. Most of the discretionary trusts that are available from life insurance providers, they are free of cost. So there's no additional charge for them. Whereas if bespoke trusts are required, which a legal professional or trust expert can put into place, that again depends on individual circumstances where professional advice needs to be taken, whether that trust is suitable for the individual needs or not.
Sure. Great. Yeah, and I was going to ask you about discretionary trusts and the cost, and obviously you've covered that. And it's a simple process because it's just basically filling up a small form, and that's it. Hari, just one question in terms of where you have assets, obviously with the background that we have with South Asian community, there may be assets across the world rather than just in the UK. In that scenario, what happens after death? What is the process to make sure that those assets are actually then either recovered for the spouse or the spouse carries on and gets the title to those assets?
Okay, another
bit of a loaded question, but
yeah. So it's one I sort of see all the time as well. So I mean, if the individual is domiciled in the UK, I mean, the wills, if they've made wills, the wills will only be valid in England and Wales. So even Scotland, if you've got assets in Scotland, they have a separate law there as well. So in regards to foreign assets, so that could be Europe, it could be India as well. I usually advise my clients to make wills in separate jurisdictions. With India as well, the assets, if they're domiciled in the UK, will have to then be taken into consideration when you're applying for the grant of probate. They will have to be sort of listed as assets, and inheritance tax will have to be paid on them as well, dependent on what the assets are. It could be foreign bank accounts, it could be land or ancestral land, which has been left from previous generations as well. But you do have to make a separate will. And even in Europe, there's Spain has different succession rules. France has different succession rules as well. I think in France, you've got to give a set percentage to your children as well. And India obviously has its own jurisdictions as well. So it's not one sort of uniform sort of law that they have in India. So you'd have to go to India to speak to a specialist there and see what impact your assets in India would then have on you. But in terms of if you're UK domiciled, these assets do also have to be taken into account for inheritance tax purposes. It can't be a case of, well, you know, I've not got them in the UK, so I can't include them. Those assets also need to be included, and they're taxable.
Ed, just following on from that, I mean, where you do have probate and you're going through the probates and where you have offshore assets, what do you need to do from your perspective for that scenario?
Well, yeah, it's about identifying it. So it's identification of the assets and liabilities. In the case for UK domiciled individual, you need to consider their worldwide assets and report them to HMRC and pay inheritance tax. Different jurisdictions will have different sort of requirements for the collection of those assets. Whether you need, I don't know, in the US, you might need a medallion certificate, which is like an insurance policy. India, where we've got to get documents notarized, legalized, and then deal with the Indian formalities as well. It basically, it depends on where the assets are, what they are, and what the requirements are of the jurisdiction. Really.
Sure. Okay. And Pranav, from your perspective, obviously, if you're somebody's contesting the wills and so on, and obviously they've got foreign assets, presumably you would be looking to get legal advice in the local jurisdictions where the assets are to see how best to deal with that.
Yeah, I think that would be very sensible, particularly, you know, if that particular lawyer that you've approached doesn't have the requisite experience in relation to wherever the property is. So yeah, absolutely. When there's an international element involved, it'll be worth, you know, going to your solicitor in the first instance. Your solicitor may have a referral network or contacts in whichever country the property is in, and they would probably be able to facilitate that process on your behalf.
Great. Okay, I think, yeah, I think we've done a great job in terms of time-wise. So again, thank you so much to all of you, Hari, Yogesh, Ed, and Pranav. It was really very, very helpful, and I think it's useful to have this session, and I think it gives them, even in a soundbite scenario for the people listening to it, it gives them a flavor of what sort of things that they need to look at once somebody has passed away. Obviously, you know, it is emotional and sensitive, but things have to be done, unfortunately, and this is the sort of thing that we can help, or at least, you know, we can help people with. But again, thank you so much for that.
Thank you. Thank you very much.
Thank you.